Mr. Subramaniam, Professor Subramaniam, Professor Tabassum, and students. Thank you for inviting me to speak to you. I'm a local Bangalorean and I have fond memories of the vicinity of your university because in addition to your excellent institution, there is another neighbor of yours for whom I have the highest regard. I don't know if many of you have visited it. It's called Nightingales. It is a center for dementia and Alzheimer's. And I had an aunt who was there for many years. So I have spent many weekends, days coming here. And though it's the first time I have come to CMR, I have driven past your place very many times. So I'm reminded of my late aunt, Ms. Padmini Murthy. And I'm sorry to begin on a personal note, but the topic which was unassigned, but I left it to my own imagination, looking at the way the day has gone on. I thought it's best for me to focus on the changing role of advocacy in the various commercial and business areas of practice. In this, my own focus has been for many years to internationalize my own practice. And it has happened both by time and technology and by good fortune. But I always feel like a elder sibling who has broken through part of this forest of international dispute resolution, which is controlled by those who are typically pale, male and stale, which is a particular part of the world, of a particular race, of a particular age, and of a particular gender. And you might have a few cracks in that ceiling, but unless there are more brethren, sisters who are able to take advantage of that, these gaps close in very quickly. So my endeavor today is to excite some of you to endeavor to practice not with alone the High Court in mind or the tax tribunal or the NCLT or indeed the various fora in Delhi, including the Supreme Court, but also think beyond. And think even when you are advising on the transactional side, not to be restricted to India. We all have to be future facing. 20 years from now, there is no guarantee that the world will have the same political borders that we see today. And lawyers have a tendency to lull themselves into complacency and can sometimes be guided by the comforts of yesterday and today to make their choices for tomorrow. And law is a notorious laggard. So the impacts on society are most immediately felt, and then law sometime down the line catches up. And this introduces tremendous dissonances. It is not possible and sustainable for India or Bangalore to have a world-class startup stroke entrepreneurial environment with a broken legal system. With a legal system that even a part of which can be accused of corruption. It is simply not feasible. And these contradictions, which we have come to accept as perilous as they are, as some form of jugaad that has worked for us so far, may certainly not work for us for much longer. And so, there are, and I would say that this is the singular benefit of practicing in different geographies. is that you are able to hold a mirror to your own legal system without waiting for your parliament to do it and without waiting for anyone else in your profession to do it. Each of you must, when you write your theses on various subjects in your legal curriculum, focus particularly on the international and the comparative aspects of the problem that you're dealing with. It could be any of the topics that my friend has just mentioned. It could be a topic from dispute resolution, it could be from competition law, it could be from IP, it could be air and space law. Whatever the topic may be, focus on the international norms that are being generated and focus on the comparative. That exercise will demonstrate to you the gaps or the strides that India has performed in that specific area of your study. And it is and when you say comparative, people often forget the 70 years of detachment that we have had from England. And often the first port of call is English law. It is an intellectual instinct that is worth curing, and it is worth being very watchful for. Because if you want to develop a Tagorean Vishwamanava approach, it is irrational to begin with England. Tagore traveled to China, to Japan, to several other parts of the world to inform that instinct, which is deeply Indian. We are international by instinct. I'm not here referring to any particular faith. I'm talking about our collective civilizational heritage. We are adept, and our strength is in thinking in universalist terms, not merely for ourselves, our families, our communities, our regions, our country, but well beyond. And we must play to that strength. And Mr. Jaitley, when he became, before he was the finance minister, when he was the law minister a long time ago, I had heard him speak at a function where he said, look at the innovation that Indian IT has managed, the miracles managed to perform at a global level. Look at Indian pharmaceuticals, look at biotech, look at India's space program. These are some standout examples of cutting-edge, globally relevant value propositions without compromising on quality, but at a fraction of a cost. And contrast that, if you may, with the legal sector. Indian lawyers at the top are amongst the highest paid in the world. Not necessarily because every such dollar or pound or rupee is well earned and deserved. How do you judge the worth of a man or a woman in gold? It's difficult. But surely it is also a factor of economics, of demand and supply. And this comfortable oligopoly that has existed for some time will not last. Though I have heard, and he would have heard for 20 years, that yes, foreign law firms are coming. It must come, and it must happen. And not only that, there must be more Indian lawyers who are able to work internationally. And I hope many of you will be not restricted in your careers to having careers in India, but having careers overseas. Now, coming to the aspect of advocacy. Now, this is also changing very, very rapidly. For example, even within India, you have different levels of exposure amongst young lawyers to trial skills. I've had the good fortune earlier of practicing in a city, that is Bangalore, where we all conducted trials. On my very first day in my senior's office, I had to conduct a cross-examination of a man who was dressed as a sadhu. And he was a former director of a company, and he had taken sannyas. But we had got a commissioner appointed, and we had summoned him back from Varanasi, saying, yeah, you might be whoever you are today, but we want to cross-examine you on your role as a director of a company at a particular previous period of time. I did a very bad job, and my learned friends on the opposite side did not help it by jeering and by taking advantage of my first-time approach. But that's the school of hard knocks that Mr. Ali Nariman talks about in his book. It teaches you greatly. And now, of course, the friends on the opposite side and I are very dear friends. But that early experience and exposure showed me that even my own colleagues in Delhi, Mumbai, Madras even, were not exposed to trial advocacy at that age and with that frequency. And so the opportunity was plainly visible to some of us, that the skills that we were acquiring were globally relevant. They're not relevant to your case here alone. And so quite often my friends and well-meaning friends, and even my wife, would speak with great concern and caution to say, are you serious? Do you really want to, when you have your cases in Canada in the next day, really want to blow up all your money on a library on international arbitration? Are you serious? On China law, why is it even relevant for conducting the land litigation tomorrow in the Neohal court? But to me, these have always been questions I could never understand, as much as people could not understand my mission to create these libraries. And each one of you is welcome, not to borrow, but to use the books that are available in my library. They range from technology and the law to space law to oil and gas to heat loss to litigating before the ICJ. And I have profited greatly from investing at an early age in areas that I know absolutely nothing about, but was compelled to learn more, just being driven to and setting that goal for myself, because nobody else would set it. And I'm a person of slightly higher than average ability, intelligence, or maybe just average, and that's it. And if I can do it, surely all of you who are more gifted than I am can do much, much more. But I don't see enough international ambition amongst members of our profession at various stages. And I see a sense of comfort setting in very early. And the worst place where comfort can exist is in your own imagination and is in your own versions of yourselves 10, 20 years ahead. You cannot let that imagination be fettered by what you're familiar with. And so with that early experience of advocacy, especially on first instance advocacy, it was apparent that these were skills that could be deployed internationally using the realm of international arbitration. And in international arbitration, you are not required to be qualified in any other jurisdiction. I am an Indian advocate, full stop. I missed the bus long ago to qualify in England, and happily so, and many other places. But it has never been necessary. It does not stop anyone from conducting arbitrations in England, in Geneva, in Paris, in Dubai, in Singapore, of course, all the time, Hong Kong, beyond. But there is, and also this institute that I would commend your attention to, which is FIA, it is mentioned in my introduction, which is the Federation for International Arbitration and Advocacy, it's based in Geneva. It's been set up by a lady called Gabrielle Kaufman-Koller to identify this skill, which is lacking not only in the big metropolises in India, but even in the global dispute resolution centers. A young lawyer in New York is not exposed to cross-examination. A young lawyer in London is not readily exposed to cross-examination. So there are these institutes that have then been built to create an atmosphere where people can learn in a safe environment. So, for example, you are then filmed in conducting a cross-examination. You are then corrected And that's a process that takes over 2 to 3 days. And these are skills that you can only learn by doing. You cannot learn them by listening, you cannot learn them very much by observing as well. You have to have the opportunity to conduct them. Again, this form of truth finding is not universal. Any example of countries where cross-examination is rare? Anyone? Which part of the world is cross-examination typically linked to? Part of the legal world? Anyone? I hear murmurs, you may as well speak loudly. Okay, I will not be easy on you. Like 20 questions. The second clue is think, as I said, beyond England. Where?
Greece.
Greece. Why not? Okay. Why do you say Greece? Because?
Like a lot of philosophy.
You're right. So that's a good thing. But do you know why you're right?
There are a lot of legal philosophers over there. Like they were advanced, well advanced.
Okay. Okay. But that's not quite the reason. The simple point is that civil law systems, which is a large part of Europe, and within civil law you have Germanic systems and then you have the French systems. The civil law systems do not ascribe as high a value to cross-examination as do common law systems. So common law systems across the world, the US to England to much of the Commonwealth, of course, focus heavily on cross-examination. But civil law systems, Greece, yes, but not just Greece, but every other continental European country. And can you please name me some more Asian countries? Yes? Yes, you're right. You're right. Say it loudly.
Japan.
Japan, and there's one more. Bigger than that? Why not? Yes?
Korea.
All 3 correct. China, Japan, Korea. Alright? Now, if you look from, again, comparative law and history, Professor Subramania will correct me on years, but it was the Belgian constitution that served as the template or the inspiration for the Japanese, which then served as the template for the Chinese, and then has been transmitted thereafter across large swathes of Asia. You had direct French colonies and French legal presence. Parts of India, like Pondicherry, where even land law in Pondicherry, for example, you need to look beyond even Goa because of the Portuguese influence, and several other parts of Asia. Indonesia was a Dutch colony. Vietnam had French influence. Laos had French influence. So then, if you start plotting the world, you will see a very different world emerging. What about South America? What about Africa? Right? You will find large parts of South America, which is the only English-speaking country in South America. Anyone? Anyone there? It has a cousin which is French. Yes? I heard you say something. It sounded right. It's Guyana. You have French Guyana, which is the French cousin, but then you have Guyana, which is the only English-speaking country in South America. Beyond that, every other country you will see is Portuguese and other languages being spoken, Spanish. Central America, Spanish. And how many votes did English lose to German as the official language of the United States of America? Again, check me if I'm wrong. It's school quiz memory of 25 years ago. But I think it's 13. So the world would have been very different if those 13 votes had swung towards Germany. the influence of civil law cannot be overstated in the world's legal systems. And if you are practicing beyond borders, you have to contend. You mentioned just now with indemnities, and then you can spend an hour's session on a comparative view of implied indemnities in civil and common law. What are the duties of a seller in common law jurisdictions? What are the bare requirements under the Civil Goods Act, let's say, in India? How do you contrast that with, say, German law on implied indemnities for fitness and purpose? All these are concepts that you will discover only if you are live to this fault line, this very big intellectually different tradition, which is civil law. And so, in international advocacy, you will find that civil law countries as well, when they practice international arbitration, they, for example, lend great credence to the written affidavit of the party. And even if it is a private forum, it might well be a crime to swear to an affidavit that is incorrect. In common law countries, you will quibble about whether there is an affidavit filed in a court, whether it is sworn to in the proper format. But in civil law countries, the written word is given great eminence. And so, when you deal with these territories, you will be able to understand the behavior of parties. For example, the idea of good faith in contract negotiation. A large part of, let's take another example, okay, of an ancient legal system. Let's take Islamic law. Look at the number of countries that follow some form of ecclesiastical law. And Islamic law is very prominent amongst them. Their approach to interest, their approach to witnesses and proof, their approach to good faith in negotiation. And I had occasion to sit as an arbitrator in Dubai, as between two parties. I was the only Indian element in the room. They just needed some third party neutral to decide. But the issues pertain to the idea of good faith in negotiation. And for many parts of the world who had a strong oral tradition, such as us, such as the Middle East, our spoken word was all that was required. We didn't require the Englishman to teach us about the gentleman's word. A large part of our own cultural heritage has been oral and has been communicated as such across generations without question. And so the oral word and the sound itself has been sufficient for many, many cultures. And so there is a dissonance, and these dissonances don't disappear easily. We spoke about a napkin contract or offer. There are more descriptions, more colorful descriptions of other such practices in arbitration, let's say. There's something called hot tubbing, where you have experts with different views sharing a hot tub and then coming out with an answer that is palatable to both parties. Similarly, when it comes to the idea of good faith as well, you will find that it forms a part of many legal cultures which is not present in India and not present in many of the common law systems. Again, it is only by studying from an early age comparative law at every chance that you can that you will discover each of these gaps and schisms. Advocacy has tended, therefore, in civil law countries to limit itself to opening submissions and strong closing submissions with minimal use of cross-examination techniques. The elements of a good opening is not a subject that is ever part of a syllabus in a law college. You might in your CPC or your pleadings and drafting course, if there is one such, I don't know what it's called these days, civil practice or something. I don't know if there is any focus paid to how do you open a brief? How do you grab and retain the attention of the judge to your facts 2 points of law that are relevant to your brief. How do you then focus on closing? What are the various forms of closing? You said Greece is a great place to start. There are 3 rules of advocacy with Greek words. Logos, logic. Pathos, which is drama. And ethos, which is
Ethics.
stature. You can argue your case with logic. You can argue your position with mirch masala, with tears, with sharp comments, with drama. You can argue your case by your mere presence. This third rule of ethos is one that advocates can achieve after long years of practice. One doesn't get a degree in ethos. You cannot get a weekend course in it. And the crude expression of that is wrongly called face value in various fora. And it is the most cynical and distorted version of a very ancient rule of advocacy. Of course it matters who your advocate is, but it matters for a very correct reason. It matters that he or she is an expert in the field. He or she is known to always state things correctly, never to mislead. And he or she is able to act as an officer of court or as an independent legal professional, not mindlessly pleading the position of the party who's engaged them for the day. Now, these are ancient rules of advocacy. Logic is not taught in most law schools. I don't know if it is taught yet. If it is not, then the place to begin is a small book called Copy and Cohen, and it's called Introduction to Logic. The best example of pathos is a book called The Devil's Advocate. This is written by a barrister who used to practice in the International Criminal Court. For example, he has very early rules of good advocacy, apart from speaking slowly and clearly, etc. It also includes being nervous. If you are not nervous, there's something incorrect about your preparation. You are not taking the opportunity of advocacy sufficiently seriously. But how do you contain that anxiety? The gentleman says, clench your toes. And let that sink in for a minute. The second rule, he says, use silence. Can you see? I just did. These are not rules that form part of our examination paper. But these are very deeply human means of communicating effectively. After all, what is advocacy? It is the ability to communicate effectively. Alright? And so, using silence is quite clear, but I'm surprised nobody asked me as to why you have to clench toes. Has anybody figured out why? Because there's no question, I suppose you know.
It builds that tension. It builds that tension.
Actually, it contains it. So the idea is to transfer your tension and your anxiety into an unseen, unpalpable, but real space. So only you know that you're tense. No one else does. It no longer shows in your voice, it no longer shows in your stammer, your stutter. Try it. And there have been other ancient examples of people, including some Bollywood stars, practicing advocacy techniques, also applicable to drama and theatre, such as getting over a stutter. So what do you do to get over a stutter or a stammer? I think it was Hrithik Roshan who says he had to do it himself. Anybody? Not meant for kids, but the idea is to fill your mouth with pebbles, ice, whatever, right? Don't choke, and then to enunciate words as clearly as possible. Now, these are techniques which one can scoff at in this modern world, but the rules haven't changed. Human beings haven't evolved biologically in a dramatically different way over 2,000 or 3,000 years. So why is it that rules of speaking and communicating must be necessarily different today as opposed to ancient Greece or ancient Rome? If it means you are dealing with the biology of communication, that hasn't changed. What has changed is the use of technology. But that has been changing for a long time. The Industrial Revolution produced one set of technologies. The digital age has produced another set of technologies. The courtrooms of today look very different from the courtrooms of some years ago. Earlier, the role of art in courtroom was very high. So if any of you visited Italy here, anybody who's been to Italy? No, not yet. A must-go place to any lawyer at some point. Not only Rome, but I would add to that Milan. And I was recently in Milan, being shown around the court by a lawyer, and it is shocking because the courtrooms in Milan have sculptures built by Mussolini. Every courtroom has a mural which is a fascist version of justice, or a fascist version of law. So for example, in the Chief Justice's court, you had an unequal scale between law and justice, where law was heavier than justice. And you had a cheeky representation of justice as a dead soul who was going to be buried, because law had become so oppressively more important than justice that it buried the figure. But Mussolini didn't see that visual joke, thankfully, and so it remains. But if you look then at several other places, the idea of architecture and justice as well has evolved. Why do these buildings have high ceilings? Why do they make you feel so small? Why is it so crowded? All of these are aspects of developing a sense of public space, public catharsis to questions. How in this world does private dispute resolution reside? Arbitration is a global phenomenon. It's here to stay. It's the most successful international convention. What's it called? Of 1958? No. UNCITRAL was established later. It's a New York Convention. The New York Convention governs the recognition and enforcement of arbitral awards. UNCITRAL was set up many years later to harmonize international law when it comes to trade and commercial law. It was set up by 8 founding countries, UNCITRAL that is. India is one of them. But it has been the least contributor of ideas. The least number of ideas have been contributed by India. And India has received ideas, which is why the UNGA, what's UNGA? Passed a resolution to set up a coordination committee in 3 countries. They said they set it up in Japan, in Australia, and India. And those of you who are interested in UNCITRAL related work, please contact me offline. I'll be glad to put you in touch with the relevant people. But the idea is to deepen the engagement of various working groups. There are several working groups in UNCITRAL. For example, there is one on reforming the ISDS system. investor state dispute resolution system. They start looking at the cross-border insolvency. There's technology law being looked at, and that's where I'd like to go to next, which is that private dispute resolution doesn't have the glamour and the public catharsis elements that I've been talking about so far, that courts have. But they have been very ancient means of settling disputes. You have never had to be a lawyer to be able to settle a dispute fairly. You've had to be a person of some common sense and wisdom, and lawyers perhaps have them less than others, or I don't know, who may think they may have more than others. But society doesn't always agree that lawyers have a monopoly over wisdom or common sense. They don't. Many people have it. And so you've had professionals, builders, architects, engineers, quantum experts in every single profession, where they've had trade guilds dating back to the industrial age and even earlier, and guilds which have had the ability to solve their own problems. You also have dispute resolution amongst religious communities, where, let's say, the Ismaili community, and there are such arbitration clauses that allow, say that the arbitrator between two people of one community, say that the arbitration must be according to the so-and-so business council, whichever community they both come from. Now these have worked. These have managed to provide a credible dispute resolution service to the parties involved. And many of them sometimes are cross-border. They're not within one particular area. For example, we look at the grain merchants associations cases. Many times the arbitrators are not lawyers. If you look at maritime arbitration, many times there are people who are recently trained in law, but sometimes also never trained in law, captains of vessels, different surveyors, and people who bring their different life experiences into assisting parties to settle their disputes. And the dispute as settled by them is enforceable in how many countries are signatory to the New York Convention? I don't know, so I don't have the answer, but you should check. It's well over 175, nearly 180 countries. So your award can be enforced in as many countries as that. And though it has been privately negotiated and arrived at between two parties. So the power of arbitration, so therefore the enforceability of an arbitral award is incomparable to a court decree. An Indian court decree cannot travel as far as an Indian arbitral award can. But with great power comes greater responsibility of the parties, for their advisors, their counsel, and of course the arbitrator. Because the arbitrators have a duty to render an enforceable award. And there are some countries, including the UAE, which now have started using criminal penalties against indiscretions by arbitrators. And of course the international arbitration community got up in arms about it and they asked them to change. But the international arbitration community is often also referred to as the mafia, in the sense that it is a closed door. People see it as a forbidding ivory tower, difficult to gain access into. I'm, for example, member of a club that I did not know existed until I was invited to be a member one day. It's almost like Groucho Marx saying, I don't like to become a member of a club that will accept people like me as members. But there are clubs like this one, which meets for lunch at Park Lane in Mayfair in London for lunch once in every 3 months. People fly from all over the world to meet for lunch and then go away. They plan their calendar for lunches in London months in advance. You will have the Lord Chief Justice, you'll have the heads of the Magic Circle law firms, the heads of ExxonMobil, a few oil companies, former Chief Justices of other countries. You're speaking at a particular venue and you hear a lecture for a few minutes and you go away. But not looking at it cynically, the idea for many years has been to build a circle of trust. And there is a book that I would commend to your attention for those of you who are interested in arbitration, which is called dealing in virtue. How do you, without a formal system of recognition of a person's competence, ability, how do you recognize a person who can be tasked or entrusted with dealing with the interests of parties and arrive at a fair and objective result? You might disagree with it, but it ought to be well reasoned and it ought to satisfy one person. Who is that one person? Awards and judgments are written for one person. Who is that? In a binary system, one wins and the other, and the award is for the losing party. It is the losing party who reads every comma, full stop, letter, logical inconsistency, missing argument, who dissects the award, who x-rays the order. How does the winning party care? They moved on. They moved on with it. It's one of the assets in their kitty. But it's the losing party who needs to be convinced that there was justice in their loss, and who will accept the result for what it is and not translate this into an endless system of appeals. And so the task with international arbitration is to identify, nurture and create a system where one could safely entrust the task of writing for the losing party. Not knowing which party is going to lose, but you're certainly going to lose, you're going to be writing an award which is going to be read closely by the losing party. And so it was in the 50s and 60s, you had a limited number of people doing this work, and so it was easy for them to create a club, invite people to it. They were all people of great eminence and great ability. But to those who were not in it, we were left with a sense of grouse or a sense of dissatisfaction or frustration that they felt that they themselves were as capable as anyone else, but they were not party to this club. All this has changed very dramatically. Now you have courses for certification as arbitrator, with the Chartered Institute of Arbitrators, for example. You have umpteen number of institutions which have now created careers and pathways for people who want to choose to be arbitrators. And many have tried, many have fallen, very few have survived. But that's the law of the jungle. That's how it is, and it's how it will be. It's not going to change. Democratizing adjudication, in my humble opinion, will simply not work. There are some early qualities that even an illiterate person might have, which a person with 2 PhDs will not have. And that quality might be most relevant for dispute resolution. But identifying them is the key. Coming to the non-adversarial side, mediation. As you can see, I'm a mediation evangelist, and it's a word that parties don't want to hear when they come to you in pain, having lost a significant amount of money or a great commercial disadvantage, or a party who is very sure of their power and saying that this is all a sign of weakness to talk about settlement, to talk about mediation. Again, the idea of ADR is not alternate dispute resolution, but appropriate dispute resolution. The same dispute may undergo several stages of evolution. The same situation might have at the very outset an opportunity for strong and direct negotiation, such as my friend when he's negotiating his contract with the opposite party. Deal is not yet done, the ink is not yet dry. Even after signing the document, you might be able to go back and say, hey, by the way, we've not plugged this gap. Let's think through and avoid a situation of adversity in future and recognize it in our contract. That situation may well pass, and when parties have come to disagreements and disputes, quite often they're far apart, and also far apart in communication. And the communication between the parties has frayed. And it is at that stage that mediation offers a very healthy, calming salve for the situation, which encourages parties to at least begin communicating. And in mediation, if there's nothing that you remember of my talk ever, please remember what I'm about to say, which is the success of mediation is not to be judged whether the matter is fully settled or not. That is irrelevant. The success of mediation is whether the scope of dispute is reduced. You might, in a situation, encounter 25 issues of fact and law that a particular dispute generates. The idea of mediation may resolve 7, 10, and that is a dramatic saving in time, in cost, in effort, in expense. And so to anyone, including yourselves, the voice in your own mind which tells you that mediation does not have a role to play in an adversarial system, that voice is plainly wrong. And mediation cannot be judged by whether it solved the Ayodhya problem. The very fact that we've had the good sense to have a civilizational conversation is healthy for our country. Whatever be the result, even if that conversation does not produce anything legally enforceable, the very fact that people are thinking beyond binaries of winning and losing, of everything or nothing, are beginning to imagine possibilities of coexistence with a negotiated and self-imposed settlement. The very fact that that is being contemplated will change the way parties approach even the formal dispute. Even after this process, the way in which the case will be conducted in the Ayodhya case in the Supreme Court will be very different from the way it has been conducted thus far, with highly politicized tones of X and Y. Each of those agendas will be thrown up. And mediation is a process where it is actually not something that you should tick the box with. I would not recommend it for law students, because I find that law students think that they have learnt and got it all by doing a course of mediation in third year law college. And therefore they don't need to now above and beyond trying to learn anything more about it. It seems like such a simple, earthy thing to learn from your grandmother's knee. Why waste any more minutes on it? That is incorrect. Why would Harvard conduct courses on negotiation and on mediation, charging lakhs of rupees? If it was as easy as that, why would people attend? And it is a skill that you must hopefully be attracted to on your own. I can only sell you the idea now, but leave it at that. But it is a skill that will help you in every part of your law practice. It allows you to recognize interests and positions of parties. It allows you to negotiate better documents at the outset. It allows you to structure your contractual relationships better. It allows you to conduct the contractual relationship in a more civilized, plain-speaking environment. You are then able to, especially relevant if you're working across language barriers, if you're working across legal cultures, the ability to calmly respond to a situation is very, very important and vital. And that leads me to another skill which is well learnt early on and practiced through life, which sounds like mediation, confused with mediation, but happily so, and that word is meditation. I cannot overemphasize the need for young lawyers to cultivate an interest in embarking on a lifelong inner journey. It is uniquely yours. Nobody else's inner journey is like yours. And as, quoting again Greek philosophers, a life not examined has not been fully lived. And that inner journey is one that is increasingly relevant in a hyper-tech digital world. Today's newspaper headline was a quote from the CEO of Mont Blanc for this region. A man who said, and I agree with him, that in a digital world, in an AI, MI world, the need to be analog only increases. And this is, again, the idea of mediation is very much linked to this rich and rewarding ability to have an inner journey in the midst of law practice. Quite often, burnout is seen at a very high rate in law practice. It is seen particularly highly amongst women. For life circumstances, even otherwise. And if you look at personality types, there's only a particular alpha type personality, for example, who remains in litigation. But that alpha type person who might be shouting and screaming and practicing pathos, right? Not so much logos in the skull, shouting and screaming. Not much ethos, perhaps, because where do you have the time to sit and imbibe and learn quietly and humbly if you're busy shouting and screaming and pushing and elbowing your way through life? But then that becomes a template as the person to be. It need not be the only template. Indeed, for example, in criminal law, Mr. Sushil Kumar, I don't know if you've encountered him in the Supreme Court as a lawyer from Allahabad. He was such a charming criminal lawyer. He would hold the brief for a person accused of 10 counts of murder. Somebody else would be, at that time, accused of Dakada or other terrorist enactments. But he would smile. He would be very well prepared. And he would pick out relevant portions, but he would conduct the case with such courtesy and politeness that the gory subject matter was almost hidden away from the very civilized manner in which the matters were conducted. And unsurprisingly, he very often succeeded. Now, this is a template of advocacy which in the international world is something which is more likely to succeed than any other. What has come to pass as the Indian approach to litigation of an over-aggressive approach, either in strategy or in sharp practice or in volume in court, is not appreciated internationally. It is most likely will backfire internationally. You will have tribunals reacting, perhaps even recoiling with any such approach by any party. And in fact, it's not just Indians, no need to feel very bad that it's only us. Americans are also infamous for it. The American lawyer is infamous in international disputes for long requests for discovery, for documents which may seem entirely irrelevant to anyone else. For a very, very aggressive tone in written communication, aggressive tones in oral argument, in cross-examination, and all of this aggression is sometimes part of legal culture. But which is why you will see that international arbitration or dispute practices are quite often headquartered in Europe. Think of each of the largest names of the law practices that have large international law practice in international disputes. Even if they're American firms, the headquarters of their international disputes practices are typically in continental Europe. And there's no reason why that cannot be in your neck of the woods. There's no reason why that can't be Bangalore. But it requires effort and it requires close coordination. The last point, when I stop there, is on the advance of technology and its impact on advocacy. At UNCITRAL, at their 50th anniversary meeting in Vienna, I was present when they displayed to all the delegates a certain example on screen like this of a dispute, which is a buyer and a seller dispute, and then the matter had to be resolved by a neutral third party. And then we were told what the dispute was, simple buying, selling dispute, and then the reasoning was provided. And so the decision was given to us all on the screen, all of us were lawyers. We were asked this following question. The question was that decision that you just saw authored by a human being or by AI? The votes in the room were split. And this is called the what test in computers? This is called the Turing test, after Alan Turing. The Turing test is to ask the general population whether they can tell whether a particular solution presented before them is the result of computing or not. And here, the AI, it was AI, generated answers, which one could tell was of a sufficiently high degree of sophistication that trained international practitioners could accept that this is fine, this is all that needs to be said in a dispute like this. What does this mean for advocacy tomorrow? You cannot be assured of a human neutral third party. Many online disputes, for example, Amazon, eBay, stuff like that, really perhaps they have thresholds for it as well, are disputes which are intermediated. You may even have the first cut template given to you by technology. And people accept it, people move on. So what does advocacy mean? Does ancient Greek remain relevant to a non-human audience? I don't know. Because, as I say, the creator often makes the creation in the creator's own image. And so very often, at least for the early years of AI, there will be human-like biases, tendencies, etc. So the early forms of generations of AI, neutral third-party adjudicators might behave in a human way. But as they find that human communication is inefficient, is not sufficiently intelligent, is not sufficiently observant, that is highly inadequate to fully comprehend a technical situation, AI might start demanding far more of, and this is not being very futuristic. You all, for example, we all have come to accept the use of word processing before sending any document out. Why do you do a spell check? You could have read it yourself. Why do you do a grammar check? You could have done it yourself. It saves you some time, right? So it's not very difficult to imagine that you will have technology tomorrow which will allow you to double check whether all arguments that have been raised by both parties have been raised. Every arbitral institution has a checklist to check whether the arbitrator has acted correctly before passing the over. That checklist can then be run by AI as much as by another part. So advocacy in the world of tomorrow, in the world of AI-enabled and AI-assisted tools will be a huge challenge and a huge opportunity. No longer will language be a barrier. So far you have kept yourself away from, let's say, dealing with Japanese law, because of a forbidding notion of the language or of Mandarin or any other language, Spanish. But if you have instant translating tools which are able to provide you reliable input, you can read any text in the world in your own language. You can converse with people from different parts. You can conduct an examination of a witness or question a person in your own language. They are answering in their own language, yet it is being recorded in a third language accurately in a way that all three parties are happy with. All of these are possible. And so it is for you to, in all this dizzyingly fast-paced changes, I would urge you to look for the more deep and steady gems of learning. They are unlikely to change very quickly. And so it was Newton who said, after having discovered so many laws of physics, that he has only taken a gentle stroll along the seashore and put a few baubles of shells and stones and pebbles in his pocket to share with the world, that he did not feel that he had plumbed the depths of the ocean to get the real pearls of wisdom. So the deeper you go, the more long-lasting is likely to be. Again, the deepest journey is within us, not outside us. And so many of these issues and disputes are manifestations of relationships gone sour. 90% of Indian companies are still family-owned, family-run. Siblings not being able to get along, intergenerational conflict, resulting in corporate conflict. Again, so there are very early and yet relevant solutions for disputes, which are right here before us, but they're not part of our law school curriculum, and therefore even lawyers who are trained many times don't familiarize themselves with those tools or deploy them. So please be thinking lawyers, read widely, travel, and stay international in your mind. Thank you.